This video provides a brief description of the case of Duffy and Google and discusses how this case continues to affect the liability of internet intermediary companies in Australia. Dr. Duffy brought a defamation suit against the US company Google Inc. and their subsidiary Google Australia. Although not created or hosted by Google, the defamatory material in question could be accessed online through Google's search engine service. Duffy claimed that the relevant search results published the material by presenting URL links to and snippets of the material. Duffy was unable to obtain relief from either of the Google companies. Let's look at why she failed against Google Australia first. Affidavit evidence showed Google Australia had no legal power to alter Google search by itself. Only Google Inc. had editorial control over Google search. Justice Milstead therefore found that Google Australia would be unable to comply with any injunction requiring them to edit Google search results. This means that, even if the court had upheld Duffy's prima facie defamation claim against Google Australia, the court's hands would have been tied, as only the US-based Google Inc. had the power to comply with the appropriate injunction. Courts are less likely to impose orders on foreign defendants due to the increased scope of their orders and the lower likelihood of compliance. By ensuring that only one head office can comply with court orders such as injunctions, internet intermediaries that carry on business in multiple jurisdictions can drastically reduce their risk of liability. Requiring relief from a foreign party as a starting point is much more difficult than being able to gain relief from a local subsidiary for plaintiffs. Justice Milstead noted that, even if Google Australia could have complied with an injunction, Duffy's claim would still have failed for the same reasons that she failed against Google Inc. Let's look at those reasons now. Interlocutory injunctions are only granted if the plaintiff passes the balance of convenience test. Plaintiffs must demonstrate that the inconvenience or injury that they would suffer from refusal of an injunction outweighs the inconvenience or injury that the defendant would suffer from complying with such an order. Justice Milstead applied this test and concluded that the balance of convenience favoured Google Inc. Three of the factors identified by His Honour are particularly applicable to internet defamation cases in general. Firstly, the public has a recognised interest in free discussion of public interest matters. This is particularly influential for internet publications which are freely and continually available. Secondly, even if the application were granted, it would not remove the actual material, only access to it through Google search. This would be an inequitable order for Google, as their competitors would not be similarly restricted. Thirdly, the grant of an injunction of this nature would require removal of the material from any Google domain accessible in Australia. This would apply in jurisdictions where Duffy may not have had the required reputation for defamation to be made out. These factors can be seen to apply due to the very nature of internet publications themselves, and would seem to apply in most internet defamation scenarios. In this way, liability in defamation for internet intermediaries becomes even harder to establish. Finally, Duffy and Google provides some guidance on the issue of publication through search engine results. Google argued that it was only a facilitator of the publication through its search results. The Google search algorithm produces results completely automatically. Google therefore argued that it had not actually authorized any publication and was therefore not liable. Google sought to rely on the UK decision of Tamise and Google Inc., which decided this issue in its favour shortly before the Duffy case. Justice Milstead considered it unnecessary to decide the argument in this case. However, His Honour did refer to the Tamise case as persuasive. This remark has since provided a counterpoint to later Australian case law which conflicts with the UK position, and is still discussed in cases considering the issue currently. In conclusion, Duffy and Google continues to affect the Australian legal landscape by offering support for further reducing the possible liability of search engine companies. Additionally, it outlines some of the factors plaintiffs must overcome if they're seeking to impose liability on search engines in defamation.